The title is Warning to California Parents. Know your rights, research the people in your case, and protect your record. Parents involved in California family court or juvenile dependency proceedings need to understand how much authority the legal system can exercise over their families. Judges, commissioners, attorneys, social workers, custody evaluators, therapists, and other professionals can influence decisions involving custody, visitation, restraining orders, reunification, placement, and relationships between parents and children. Parents should not assume that every professional involved in a case will automatically perform every responsibility correctly. California's own public disciplinary records demonstrate that judicial misconduct has occurred, while California also maintains professional rules governing attorneys and detailed requirements governing court-ordered child custody evaluators. This does not mean that every judge, attorney, social worker, evaluator, or other professional is corrupt. It means that no professional exercising substantial authority over a family should automatically be considered beyond accountability. When government agencies become involved with families, meaningful judicial oversight is essential because courts should independently consider the evidence necessary to make legally required findings, rather than treating the conclusions of an agency, evaluator, attorney, social worker, or other professional as automatically correct. The title is Judge Emily T. Spear, Los Angeles County Superior Court. Judge Emily T. Spear was publicly admonished by the California Commission on Judicial Performance on September 6, 2023. Her misconduct occurred while she was assigned to the Family Law Division at the Compton Courthouse. The Commission found numerous unauthorized and undocumented absences and early departures, and her absences affected matters requiring judicial attention, including temporary domestic violence restraining order petitions. The Commission also found that Judge Spear made disparaging remarks about another judicial officer, engaged in discourteous conduct toward her supervising judge, made false statements to her supervising judge, and manipulated her calendar for personal benefit. The Commission concluded that some of her misconduct reflected a lack of integrity. This is significant because these findings did not come from social media accusations or dissatisfied litigants alone. They resulted in official public discipline imposed by California's Judicial Disciplinary Authority. The title is Commissioner Alan H. Friedenthal, Los Angeles County Superior Court. Commissioner Alan H. Friedenthal received a severe public admonishment from the California Commission on Judicial Performance in 2012. His misconduct involved 5 family law cases, and the Commission's findings included discourteous and denigrating behavior, conduct conveying an appearance of bias, improper ex parte communications, failure to disclose information reasonably relevant to possible disqualification, and investigation of information outside the court record. In one proceeding involving teenage parents and their child, Friedenthal failed to disclose information concerning his previous relationship with an attorney appearing before him. He previously had provided character testimony concerning that attorney and attended the funeral of the attorney's husband. The Commission determined that this information was reasonably relevant to whether Friedenthal should be disqualified and therefore should have been disclosed. His disciplinary case demonstrates why judicial impartiality, disclosure of relevant professional relationships, ex parte communications, and potential conflicts deserve serious attention when families appear before a court. The title is Former Commissioner Robert Driessen, San Bernardino County Superior Court. Former San Bernardino County Superior Court Commissioner Robert Driessen was publicly admonished by the California Commission on Judicial Performance on December 11, 2025. The Commission found multiple acts of misconduct reflecting abuse of judicial authority and failures involving impartiality, competence, diligence, and fairness. His misconduct included issuing an improper restraining order, improperly modifying orders entered by other judicial officers, improper conduct concerning fee waiver applications, and other abuses of judicial authority. One portion of the disciplinary proceeding involved a San Bernardino County dissolution matter in which Driessen ordered an undetermined amount of money donated to charity. The Commission determined that the order was unauthorized and constituted an abuse of judicial authority. His case demonstrates that substantial judicial authority does not place a judicial officer beyond ethical rules, procedural requirements, or independent discipline. The title is Judges must carefully examine every individual case. Every family is different, and every case can contain different evidence, witnesses, documents, allegations, histories, and disputed facts. Courts should not approach cases as though an agency report, professional recommendation, custody evaluation, or allegation automatically establishes the truth. A court may receive reports, declarations, testimony, evaluations, visitation information, documentary evidence, previous orders, and competing descriptions of events. Important statements may be disputed. Documents may contradict allegations, witnesses may disagree, and earlier records may conflict with later reports. Judges are responsible for deciding the issues presented under the applicable law and evidentiary standards. A parent's disagreement with a government agency does not automatically establish that the parent is dishonest, dangerous, or uncooperative, just as someone's position as a government social worker does not automatically establish that every factual assertion or conclusion in that person's report is correct. When material facts are disputed, courts should meaningfully evaluate the evidence necessary to make the required findings rather than treating institutional recommendations as substitutes for independent judicial decision-making. The title is Child Welfare Agency Recommendations should not replace judicial review. Child welfare social workers perform an important governmental function, but their reports and recommendations can profoundly affect parents and children. Parents may dispute statements attributed to them, witnesses may deny making statements attributed to them, documents may contradict important dates or allegations, important context may be missing, and later reports may conflict with earlier records. When discrepancies concern material issues, parents and their attorneys should identify them and present them through appropriate legal procedures. A judge should not automatically assume that a child welfare agency is correct merely because it is a government agency, but a court likewise should not automatically assume that a parent is correct simply because the parent disputes the agency. The purpose of a fair hearing is to determine what the evidence establishes under the applicable legal standard. Independent judicial review is especially important when government recommendations could substantially interfere with the relationship between a parent and child. The title is Parents must receive a meaningful opportunity to be heard. A fair hearing should involve more than allowing parents to sit in a courtroom while decisions are made about their families. Parents should receive the procedural protections applicable to their proceedings, understand the allegations and issues being considered, and have an appropriate opportunity to respond. Depending upon the proceeding and applicable law, this can involve presenting relevant evidence, challenging disputed evidence, questioning witnesses, raising appropriate objections through counsel, and identifying material inaccuracies in testimony or reports. Government agencies can possess resources and institutional experience that individual parents do not have, which makes meaningful representation and independent judicial oversight especially important. The courtroom should be a place where relevant evidence can be tested according to applicable law rather than a process in which one side's professional status automatically determines credibility. The title is California Rule of Court 5.22 and Child Custody Evaluators. California Rule of Court 5.22 establishes important requirements concerning specified court-ordered child custody evaluations in family law proceedings. The rule requires evaluators to maintain objectivity, control for bias, gather balanced information, and consider the health, safety, welfare, and best interests of the child. Evaluators are also required to present relevant information, including information that does not support their conclusions, and to disclose significant limitations affecting their evaluations. California's rule also addresses conflicts of interest and dual relationships, while courts must establish procedures for receiving and responding to complaints regarding evaluator performance. Local rules must address ex parte communications involving evaluators. These safeguards demonstrate that an evaluator's recommendation should not automatically become unquestionable merely because the evaluator was appointed by a court. Parents and attorneys should carefully review custody evaluations for material inconsistencies, omitted information, unsupported conclusions, potential conflicts, limitations, and relevant information contrary to the evaluator's conclusions. Rule 5.22 concerns specified family law custody evaluations, however, and should not automatically be characterized as governing every juvenile dependency or CPS proceeding. The title is Attorneys must be held accountable too. Parents often depend heavily upon attorneys because family and dependency proceedings can involve complicated statutes, evidentiary rules, objections, deadlines, hearings, and appellate issues. California attorneys are governed by enforceable professional obligations, including requirements concerning competence, diligence, and communication with clients. An attorney representing a parent should understand the relevant record, communicate appropriately with the client, identify significant factual disputes, evaluate important evidence provided by the client, consider appropriate objections and legal arguments, question witnesses when necessary and legally appropriate, and protect issues requiring further review. An attorney's physical presence in the courtroom does not by itself guarantee meaningful representation, which is why communication and preparation between the attorney and client are important. Parents should provide important evidence to their attorneys in an organized manner and clearly identify documents contradicting significant allegations. Counsel can then evaluate whether and how that evidence may lawfully be presented. At the same time, disagreement with an attorney's strategy or an unfavorable court outcome does not automatically establish professional misconduct, because misconduct must be evaluated according to the particular facts and applicable professional rules. The title is California Rule 4.1, Attorneys Must Be Truthful. California Rule of Professional Conduct 4.1 addresses truthfulness in statements to others. While representing a client, an attorney must not knowingly make a false statement of material fact or law to a third person. The official commentary explains that a misrepresentation can also occur when a lawyer incorporates or affirms another person's statement that the lawyer knows is false, while partially true but misleading material statements or material omissions can constitute false statements in certain circumstances. This distinction is important for parents who believe inaccurate information was presented during their proceedings. An inaccurate statement or disagreement does not automatically establish attorney misconduct. Parents who believe a knowing material misrepresentation occurred should identify the exact statement, determine where it appears in the record, preserve the evidence contradicting it, and identify any evidence supporting the contention that the attorney actually knew the information was false. The title is California Rule 4.2, Communications with Represented People. California Rule of Professional Conduct 4.2 generally prohibits an attorney representing a client from communicating directly or indirectly about the subject of the representation with a person whom the attorney knows is represented by another lawyer in the matter without the other lawyer's consent, subject to specified exceptions. The official commentary also addresses attempts to communicate through intermediaries, including agents, investigators, or clients. The rule contains important exceptions, including certain communications authorized by law or court order, and provisions involving communications with public officials. Parents should therefore examine the complete rule and circumstances before concluding that a particular communication violated Rule 4.2. The important point is that professional rules exist governing communications with represented people, and attorneys cannot simply disregard those requirements. The title is California Rule 4.3, Protection of Unrepresented People. California Rule of Professional Conduct 4.3 establishes protections for unrepresented people communicating with attorneys. An attorney communicating on behalf of a client cannot state or imply that the attorney is disinterested. If the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role, the attorney must make reasonable efforts to correct that misunderstanding. The rule also limits legal advice that an attorney may provide when the interests of an unrepresented person conflict with those of the attorney's client. This is important because an unrepresented parent or another person interacting with an attorney should understand whom that attorney represents and should not be misled into believing that an opposing attorney is acting as a neutral advisor. The title is California Rule 4.4, Duties Concerning Inadvertently Transmitted Writings. California Rule of Professional Conduct 4.4 addresses writings that an attorney receives inadvertently. When it is reasonably apparent that a writing was inadvertently transmitted, and the lawyer knows or reasonably should know that it is privileged or protected by the work product doctrine, the lawyer must refrain from examining it beyond what is necessary to determine its protected nature and promptly notify the sender. This rule demonstrates that professional responsibilities continue even when potentially advantageous information unexpectedly reaches an attorney. Attorneys remain subject to ethical requirements governing how protected information is handled. The title is California Attorneys may be required to report serious misconduct by other attorneys. California Rule of Professional Conduct 8.3, effective August 1, 2023, created an affirmative reporting obligation under specified circumstances involving serious misconduct by another attorney. When the requirements of Rule 8.3 are satisfied, a California lawyer who knows of credible evidence concerning specified serious misconduct must report it without undue delay to the state bar or a tribunal with jurisdiction to investigate or act upon the misconduct. The rule addresses specified conduct involving criminal acts, dishonesty, fraud, deceit, reckless or intentional misrepresentation, and misappropriation of funds or property when the conduct raises a substantial question regarding another lawyer's honesty, trustworthiness, or fitness as a lawyer. The rule also contains important exceptions involving confidentiality, privilege, mediation confidentiality, and other protected information. Rule 8.3 does not require attorneys to report every mistake, disagreement, unsuccessful legal argument, or questionable strategic decision. Its specific requirements must be satisfied. Nevertheless, the rule establishes an important accountability principle because responsibility for addressing serious attorney misconduct does not always rest solely upon clients or members of the public. The title is Powerful Warning 2, California Parents. Parents should not enter family court or juvenile dependency court assuming that every person involved will automatically identify every mistake or protect every legal interest for them. Parents should remain actively involved by reading reports submitted about their families, reviewing court orders, preserving documents and correspondence, organizing evidence, and creating a chronological timeline that makes important dates, allegations, recommendations, and contradictions easier to identify. When something important appears inaccurate, parents should identify precisely what is disputed and locate documentation supporting their position. Important evidence should be communicated clearly to counsel, while parents should ask questions when they do not understand what is happening and pay close attention to hearings and deadlines. Parents can also research publicly available licensing and disciplinary records concerning professionals involved in their cases when appropriate. If a parent believes a judge committed misconduct, the concern should be more specific than simply saying that the judge is corrupt. The stronger approach is to identify what allegedly occurred when it occurred, where it appears in the transcript or record, what ethical or legal requirement may apply, and what evidence supports the allegation. The same approach applies to attorneys, social workers, custody evaluators, and other professionals. If a parent believes an attorney failed in the representation, the parent should identify the particular action or omission, preserve communications and filings, identify the professional obligation that may apply, and document how the issue affected the representation. If a parent believes a social worker made an inaccurate or false statement, the parent should identify the exact statement and preserve reliable evidence contradicting it rather than relying on a generalized accusation. Documents are stronger than rumors, court transcripts are stronger than assumptions, and official disciplinary decisions are stronger than unsupported accusations. An organized and verifiable record can make concerns substantially more credible. Parents must also understand that filing a professional complaint does not automatically change or overturn a court order. Judicial complaints, state bar complaints, licensing complaints, objections, motions, appeals, and writ proceedings serve different purposes and can have different deadlines. Parents should not allow a disciplinary complaint to distract them from important deadlines within their underlying court proceedings. The title is The Public Can Research California Judges. The California Commission on Judicial Performance maintains an official resource called Decisions by Judge's Name, allowing members of the public to research publicly available disciplinary decisions involving California judicial officers. The records include different forms of public discipline and other dispositions, allowing parents, attorneys, journalists, researchers, and advocates to examine what California's Judicial Disciplinary Authority actually found rather than relying solely upon social media accusations. Members of the public should read the actual underlying disciplinary decision before making allegations concerning a particular judge or commissioner. The type of case also matters because misconduct occurring in a criminal proceeding should not automatically be characterized as family court misconduct, while misconduct occurring in family court should not automatically be characterized as juvenile dependency or CPS misconduct. Public records also do not necessarily represent every complaint ever submitted against a judicial officer because confidentiality rules limit what becomes publicly available. The title is Final Warning to Parents. Accountability does not mean automatically assuming that every judge, commissioner, attorney, social worker, custody evaluator, therapist, or government professional is corrupt. Accountability means recognizing that no professional exercising substantial authority over families should automatically be treated as beyond scrutiny professional standards. Judicial review, or lawful disciplinary procedures. Judges must comply with applicable law and judicial ethical requirements. Attorneys must comply with California's rules of professional conduct. Custody evaluators must comply with applicable court requirements, and government professionals must perform their responsibilities according to applicable law. Parents likewise have responsibilities to participate appropriately, communicate with counsel, comply with lawful orders, and preserve information relevant to their cases. When children and parent-child relationships are at stake, evidence, due process, impartiality, competent representation, and accountability matter. Parents should learn their cases, read their records, preserve their evidence, understand their court orders, communicate with their attorneys, research public disciplinary information where appropriate, identify material inconsistencies, and pay close attention to legal deadlines. The strongest demand for accountability is one supported by verifiable evidence.